Okay, good morning, everyone. First of all, happy Saturday morning to everyone, and thanks, John, for your time to uh, coming and spending your time on the weekends and explaining about this very important uh, thing about our I mean, about the will and trust. Um, we had earlier, few days ago, we had a session one as well. Now this is a session two with John now. So this is something, India Association of San Antonio, wanted to I mean, to promote this, help to educate our members to, understanding the important things about the family situation. Okay. Um, yeah, now I would like to, John, please go ahead and get started. And then at the end, we'll ask the Q&A. I'll find out all the Q&A and then we can answer those.
Yeah, it sounds good. Hey, thank you everyone for having me on. I've been working with your community for a long time. I am an attorney. I've been doing wills and trusts here in Texas for over 20 years, and this is all I do: wills, trust, and probate. We call it an estate attorney. So this is my expertise. I've probably worked with about 300 families in San Antonio. I've done about 10,000 trusts since I've started. I'm based out of Dallas, but I come down to San Antonio every 3 weeks. So, I'll come to your home. I make it easy and help you set up your estate plan. So enough about me, and let's talk a little bit about what we're going to cover. We're going to cover probate and estate planning, how that all goes together. So estate planning, there's two types of estate planning. There's the estate planning you do with your financial planner to make sure that you have enough money for retirement. And then there's my type of estate planning to make sure that if you become incapacitated or if you pass away, the right people are in charge of you, in charge of your estate, and the right people receive your money. So money in Texas doesn't automatically transfer to your heirs, and no heir has a God-given right to receive your property. You've developed this income, these assets over the years. We have mechanisms for you to make sure that you can give them to the people you want and not to the people you don't want to receive your estate. So a little bit about what is probate? So sometimes it's a scary word. Sometimes attorneys like to scare you with it, but it's not that scary. So probate is the mechanism in court when someone dies to administer the estate. So when someone dies here, property doesn't just automatically transfer. There's a lot of countries where property will automatically transfer to your rightful heirs, to your spouse. In Texas, that doesn't happen. So what you have to do is you have to go to court and you have to go to probate. A lot of people think if they have a will, then they avoid probate. And that is not true. A will is not valid until a judge says it's valid. So if you have a will, you have to go to probate. However, a good will done right with all the issues kept in mind and addressed usually gets through probate here in Texas pretty easily. But now if you have a really bad will or someone pulled it offline, didn't do it under the requisites of a proper will, probate can be a nightmare. Probate could also be a nightmare if you don't have a will. So what happens if you don't have a will? They have to do what we call a determination of heirship. That's where a second lawyer and an investigator investigates your family and makes sure that these are the rightful heirs, determines the heirs, and then makes you pay a bond, and then the estate gets tied up for a long time and it costs money. So the way to avoid that horrible probate is to at least start with a will, a properly done will executed with the formalities and addressing all issues that need to be addressed in a will. That'll make the probate easy, but you still go to probate. So how do we avoid probate? So we avoid probate through many different ways. So the most popular way is the trust. You do what we call a family revocable trust. And then the other way is through beneficiary assignments. So on all your accounts, making sure you have proper beneficiaries assigned. If you have a business, in your business, you have language in your organization doc or bylaws that say that this should flow through your trust, or beneficiary language. So there's a lot of different things. That's why, there's places like LegalZoom and so forth that does proper, correct forms, but they don't address the issues. I had someone the other day show me a trust, and it listed their 4 properties in Exhibit A of the trust. That doesn't mean anything. If the properties aren't actually deeded into the trust, then it's not part of the trust that has to go through probate. And that's why we always do a backup will whenever we do a trust, because if you did have to go to probate, you want a will. So what my job is, and what a custom estate planner's job is to make sure your estate follows your wishes in the easiest way possible. There are actually people that want their estate to go through probate because there is a little more accountability with probate. However, if you have a good family situation, it's better to avoid that. Probate still, even in a simple probate, still costs money, costs time. You cannot go in there without an attorney. So that's a little bit about probate. So what should we address when you do an estate plan? A custom estate plan should take all family issues into consideration. For example, if you have children under 25 or 21, we want to make sure that they don't get the money at 18. If you have your kids on as beneficiaries, they're going to get that money at 18. Maybe you're fine with your kids getting the money at 18 and they're mature and can handle it. Most cases, I know how I was in college, that probably wouldn't have been good. So we put provisions in there to protect the money until they're 21, 23, 25, to make sure we have protections. Those should be in any will or trust plan. If you do a trust, we'll make the beneficiary of your big accounts, life insurance, financial accounts, etc., the trust, to make sure it flows. So if you have young kids, we want to make sure you address those. If you have kids under 18, one of the most important reasons why you should at least have a will is to address who would be their guardians. Because if you have no will or anything, no one knows who to give the kids to, and they're just not going to hand them to anyone. So they could show the will and at least take your kids. I have a lot of people whose families are from India, so their people are in India as guardianship. That's okay, but we appoint a temporary guardian here in the States who can at least take the kids, and the kids don't go to into state custody or foster care until someone can petition the court. If you have a child with special needs, very important that we have those addressed, because if they don't and they inherit, it could affect benefits. Also, we don't have protections in place because they might not know how to manage that probate. So those are things that should address in an estate plan. Avoiding probate is something we should address. A big deal was value of the estate back in the day. The estate tax used to be really low. And so we had to do things to address estate tax. Now, if you're an American citizen, the estate tax is 26 million. It was being sunsetted to 14 million, but I haven't read that new bill came out, but I think that bill addressed the estate taxes and moved it back up to that 26 million. But either way, if it didn't, it's 14 million. But we're going to get some knowledge on that coming up. But if you're a non-citizen, then estate taxes are something that can be addressed through the trust. If you have charities, we want to make sure those are named. If you have weird family dynamics, we need to talk about those. If you have 2 kids and one's a pain in the butt, maybe you don't want that one in charge of the estate, or the other siblings having to deal with that. If you have someone estranged, if you don't have a will or trust, they're going to inherit your estate. So that's why you need to have all this stuff to um, all together to make sure that you have a correct estate. So I'm going to take a little break here. I could keep going, or we can just pause for a question or two. What do you think?
Yeah, I
Okay,
mean,
I'll
yeah,
keep.
if you want to take a pause, that's be fine. Yes, John.
Okay, does anyone have a question? And right now,
If you, yeah, you feel free to type it on the chat. If you want it, I can ask it later at the end of the session, or if you have any questions, you can start asking now.
yeah, and if you do have a chat, I'll stop and address it along the way. So what I'm going to do is keep going, and then oh yes, Gakko, Mr. Posani, no, non-citizens definitely need a will or trust, probably more than citizens, because if you have assets, you need to have those adhered to, and probate doesn't go away if you're a non-citizen. So if you have assets here as a citizen, or you have kids, all these same issues need to be addressed. The only issue you as a non-citizen is you have some gifting and estate tax issues that should be addressed with your CPA and estate attorney. And then someone put on the chat, do you provide these services? This is all I provide. All I do is custom estate plans for people. I've been doing it a long time, and I come down to San Antonio and make sure that your estate gets adhered to. And then, so how do we achieve these results? Through a custom estate planning. You can do it. You can achieve it through doing wills. You can achieve it through doing a trust. Beneficiary designations, transfer on death deeds. That's a way to have your home transfer without putting it into a trust to somebody. It's a deed. Survivorship language in your LLC. Every one of these should be looked at. Now, you should also know that that your attorney should make sure that we do things as easy as possible. If you have two kids that are in their 30s responsible and you want them to receive the money 50-50, we don't need to flow that, and we don't have an estate tax issue. We don't need to flow that through the trust. A lot of attorneys that are charging a ridiculous amount of money want to put everything in the trust. We don't want to put things in the trust if we don't have to. We just want to make sure your estate transfers as easy as possible with your wishes adhered to. And then the last thing is, as I said before early, a trust has no value unless it's properly funded or used. So, and then that's a great segue. Anil, what is the best way to fund a trust? Working with your financial planners, your CPA, and your attorney, we decide what assets we want to put into trust. So sometimes you're going to put assets, you're going to put your financial, you're going to put your investment account into the trust. We always put properties you own into the trust unless they're in LLCs. So if you have 4 rental properties and they're in your name, we want to move all those to the trust. We want to make sure we have proper language in your trust and in the deed for your homestead to make sure Bear County knows to carry your homestead. So that's very important. Most of the time, financial accounts, we just use the trust as a beneficiary instead of moving assets into trust. We don't want to move IRA assets into the trust, but we can use the trust as a beneficiary if you have young children to protect it. And then, because of the Secure Act, and if you move your IRA into the trust, then there could be a taxable event. We don't want taxes. The one thing about the revocable trust, it really doesn't help you with taxes, but it doesn't hurt you unless we build it for estate planning purposes. But as I told you, the estate tax is extremely high. So, like I said, the estate tax between two parties, American citizens, is about close to 26 million. It was being sunsetted to 7 million each. So it was actually 5 million, and then also added with inflation. That was a whole formula. to 7 million each, which it was 14 million. However, I think the new bill addressed it back up. So U.S. citizens, maybe 0.1% have that issue. Non-citizens, there are issues with property being inherited here. Those exemptions are way lower, and so there's a lot of gifting and so forth that you do with your CPA. I know a good CPA in San Antonio that's really good at working with international clients to make sure that they're not having taxable events, and then they usually work with me and let me know any adjustments I need to make in your estate plan. So that kind of covers will and trust, a little bit about probate. Let's see. One of the other things that you should always have with any type of estate plan is powers of attorney. So there's two types of powers of attorney. There's financial powers of attorney and then medical powers of attorney. So the financial power of attorney is a good document to have for your spouse, and later on when you become senior citizens, to have your kids or somebody you trust to be there just in case you become incapacitated. Someone can handle your day-to-day financial affairs. Speak with the bank, speak with investment. If your spouse has dementia or Alzheimer's, it's a good form to have because it'll allow you to be able to handle the day-to-day assets that were in that spouse's name. Because once someone becomes incapacitated, they can't do anything. They don't have the capacity to sign a check, to sign a transfer on death designation. So a financial power of attorney is something very important. I provide those with every will and trust plan. The other type of plan is a medical power of attorney. So a medical power of attorney says that somebody can make medical decisions on my behalf if I'm unable to, I'm unconscious. Now, spouses already have this for each other. You automatically, as a spouse, have HIPAA rights with your spouse and can make medical decisions. But you still do this form because the other component of it is, which you don't have unless it's in writing, is the medical directive that's attached to this. The medical directive allows you to have a say, saying that, yeah, if I'm in that irreversible condition, I'm brain dead, my spouse can remove me from life support. Or I don't want to be removed for life support. And then you can put some extra additional directions. I don't like doing all that because hospitals like this standard form. But the most important reason is it gives HIPAA rights to a non-spouse. Your kids do not have HIPAA rights for you. So you would think that you both are in an accident, your kids can make a medical decision for you. Technically, no. A lot of hospitals will work with them, but having that medical power of attorney, it gives the kids HIPAA rights. They'll be able to execute your wishes and make medical decisions for you. Or if you don't have kids, or you have minor kids, it can allow another family member to do it. So it's very important to have those medical powers of attorney. Now, the medical directive is not a DNR. It does allow your spouse to remove you from life support and irreversible conditions, but they try to save your life. A DNR is something that attorneys don't do. A DNR is something you would either get in hospice or you can do with your doctor. If you get sick, a DNR allows you to really get specific on what treatments you want and what you don't. We don't like to put those in the directives because then they get tied up in compliance and it's sitting on an attorney's desk when you're sitting on life support. The DNR is a form that really gets specific on your wishes, and you'd work with your doctor. So if you need a DNR, I have those forms at any time, but that's something you'd work with your doctor and fill out. Another thing is when your kids turn 18, you no longer have HIPAA rights for them. Now, if you're in a hospital, most hospitals will talk to you, work with you. But if it becomes to a fundamental decision, they could turn away you being able to learn about what's happening with them. So we always recommend when the kids go away to college to get a medical directive, POA on them. And if you're a client of mine, I usually do those for free. You'll send me an email. My kid turned 18. Can you send me the POA? I'll email POA. they'll sign it in front of a notary and you'll be good to go. So whenever you have a custom trust plan, you will have a revocable family trust. So a revocable means that you could change it and update it at any time. So it's good as your life changes, that changes. We don't list your assets into trust because we don't want to have the trust, you switch from bank to bank or assets. We don't want to have to update this trust constantly or have it wrong, but we need to fund the trust accordingly. So you'll either have beneficiaries assigned to trust a beneficiary, properties need to get in the trust. So when you do get a new property, we don't update the trust. You just call me, we add a deed and record it and record that property under the trust. So you have a revocable trust. And that trust can become irrevocable, meaning it can't be changed after you die if you have provisions in there for minor kids or protections for your kids until they reach 25, or you have supplemental needs provision. Then that trust becomes irrevocable. While you're alive, you want it revocable. Plus, you can't put your homestead into an irrevocable trust or you'll lose your homestead designation, which will cost you a lot of money. Your homestead's allowed in a revocable trust. So you have your revocable trust. Then you have a certification of trust that certifies the trust. It's a little mini version that you, if you have to give someone a copy, you don't have to give them the whole trust. You have a will for each party. It's called a pour over. It says everything can pour into the trust, and it's there as a backup for the trust in case your estate has to go into probate. Pretty much says the same thing: who gets your money, who handles your estate, and whatever other provisions that we discussed. Then we do 2 financial powers of attorney that we just talked about, the 2 medical powers of attorney, which include the directives and the HIPAA, and then we do any deeds that move properties into the trust. That's a full revocable trust plan. That's a typical husband and wife or single person gets here in Texas or pretty much in almost every state here. These are also good state to state. Wills have U.S. wills have been recognized in many countries, but I always say if you have international properties, your American will has value, but I would make sure you have everything buttoned up there with beneficiaries or know if the law automatically allows it to transfer without wills. But here in the States, this revocable trust will make sure your wishes get adhered to. So that's really my presentation. And so the best part now is any good questions that we can get more specific.
Yeah, thank you, John. Yes, so on the call, if you have any specific question, you can ask him directly, or you can type it on the chat. Anyway, it's fine.
Yeah. I also want to say, well, share my contact information, and then let's see. I don't use Teams a lot. I use Zoom a lot, so let me find the chat. I could chat my information, and then feel free if you ever want to give me a call or you have a question to shoot me an email. I'll also put my website on here. You can learn a little bit about me. So I'm gonna Kalpesh, I'll get your question in 1 second. I'm just gonna finish this chat. Last my email. All right, Kalpesh, go ahead.
So what is the charge? How much do you charge and what does that include?
Okay, yeah. So everything that I outlined before, the trust, the certification of trust, the 2 wills, the 2 durable powers of attorney, the 2 medical powers of attorney, and the 2 deeds. My normal rate is $1,000 for all of that. Most law firms charge about $2,500, but for your group, I charge $650, and that covers the recording fee for the first for the homestead. But if you have extra properties, I don't charge you any extra, but we have to pay recording fees. So if you have two properties, there's an extra 35. That's my rate going forward. When I started with this group about 5 years ago, it was 550, but everything's went up at 650. However, what I am going to do for just this group or members of your organization for my next two trips, which is next week and then the 3 weeks later, so that's third week of June, I'm going to go back to that 550. And that's a great rate, and that's for everything, the trust, the wills, the powers of attorney, and all that. And I come to your home, and so the plan is I come to your home. It's about a 30-minute meeting. I gather all the information. Then I email you the documents within 1 week. And then if you're ready, the next trip, I'll come by and notarize them. It's included. If you're not ready that first trip or we can't connect on days, then the next trip. So, I keep on that format unless you have like an emergency or you have, I'm going to India in 3 weeks and I want this done, then I'll work with you. But you're going out of town in a month, call me sooner rather than later.
Yeah, just wanted to say that again to everyone that, since John is planning to come to San Antonio every other 3 weeks, if you, he can come to your home and talk to you in person, what exactly you need. So please make use of this opportunity so that you can ask him, you can work with him directly. So the another question also we have, John, they're asking, Vishnu asking, do you use Austin as well?
Yeah, so what I do is every 3 weeks, I do a day in Austin, a day in San Antonio, and a day in Houston. So I do cover Austin. Most of my business in Austin is, I'll go anywhere in Austin, by the way, but most of my business is up in like Cedar Park, Round Rock, Leander. For some reason, that's where most of my referrals are coming. Just like I have neighborhoods like Steuben, Stone Oak, and Sienna in San Antonio, where I've done dozens and dozens. I do. When it comes to funding support, I will do an addendum for your LLC, which is included. I'll do the deeds to move homes into the trust. For funding support, I'll let you know, hey, you need to move this asset into the trust, or you need to make the trust a beneficiary, but I won't do that because they won't talk to me. So if you have to go to Fidelity, you will have to be one who goes to Fidelity or goes on your work platform and makes the trust the beneficiary. But I'll give you an idea with the funding support. Also, your financial planners will help you with that too. And I do include the medical power of attorney for the kids, as long as they're college age, 18 to 22. If you have a 27-year-old that has an apartment somewhere, they can call me and, buy their own medical POA. But your medical POAs are included in the plan, and any of your kind of college age kids are included even in the future. If they're like 17 now, we can't do it until they're 18, but you'll just call me and it'll be included.
Okay.
All right.
I think you answered the questions from Anil as well. Okay. Any other questions from anyone on this call? And also, this meeting is fully recorded from the beginning, so John is okay to share with you all. So as soon as the meeting's over, I will also download and share with you as a link to revisit. You can listen again if you all want. So, John, when are you? I know you said when are you planning to come to San Antonio the next visit?
Yeah, I'll be there Thursday the 29th, and so I don't have a lot of spots open for that, but there are spots open for who gets a hold of me. And then hold on, let me I'll find you my next date.
Okay.
And then on the 23rd, I'll be in San Antonio all day.
Okay. Yeah. Yes. Definitely. Team. Make use of the opportunity to meet with him directly. And as I said, he is also willing to work with you for a special rate for the who refers to the India section of San Antonio. So yeah, please make use of it. And Vishnu is asking the dates for Austin as well, John.
Let's see. Um, yeah, Austin, I was just at. Usually I go in a row, but let's see. It depends on what I know I could fit someone in on because I'm actually in the morning on the 29th. I am in Austin, and then I'm heading to San Antonio because I just have a quick thing I have to drop by the court in the morning. But I could probably fit someone in on the 29th, and then either the 23rd, either that Sunday, the 22nd, or the 24th. I'll be doing Austin
Okay,
of
Vishnu, you
June.
got the date right? Yeah.
Yeah, just call me and we could talk about it. Depending on where you're at, we could figure this out.
Okay. Thanks so much, everyone. I think anyone has any other questions before
Hey,
we?
John, if there is any change after that, if say if we pay you 550, and then if there is any change down the road, 10 years down the road, do we have services available through you for any fee, or is there any charge?
So there's no charge fees to like call me and say, "Hey, hey, John, I got this new asset and for advice." Advice is free. If I do make a change, unlike most law firms who hammer you on changes, I charge very little. It could be anywhere from $25 to $50. If you're adding, just like you call me a year and I got a new property and you're adding a deed, I charge $10 plus the recording fee. So minor changes are like $25. A little more major, is 50. So it's very minimal. Because I don't want to discourage you from making changes because your life changes. But yeah, there is a small fee for changes, and I am there for you as God, willing. I'm here. So I do have backup, but and I do have a whole succession plan. But you don't know how that you just don't know what your backup's gonna do or not do. So, but yeah, I plan to be doing this for a long time still. So I'll be there to support you. Every step of the way.
Thank you.
Okay. Thanks, John. I think I would also like to meet you when you are coming to San Antonio. I also have a few other questions I will ask you directly. Okay.
Yeah. So what we do is, what I like to do is have a quick phone call with anyone before I meet them. So just call my number, and then I go over everything I just went over. Not as long, but a few minutes. I answer any questions, and then I'm kind of prepared, and you're prepared for the meeting, and then we'll set up the meeting. So just Raja, just give me a call, and then we'll get you set up. So, if you want to give me a call after the call, if you want to talk for a few minutes, or if you guys are meeting, just give me a call. And I'm usually available anytime. If I don't answer, I'm really good at getting back to everybody. And then can you provide a list of the documents? So what I'm going to do is I'll send Raja an email that lists those documents again, and he can forward it to the group.
Yeah, sure. Deepti, I will forward that documents after I get it from John. Okay.
All right. So I appreciate everybody's time today, and I look forward to meeting with everybody in the group, or answering your questions, or being of assistance. And like I said, if you need me, I shared my info, and just give me a call anytime.
Yeah, again, yes. Thanks, John, for your time. And this is something very important for our our Indian community here, especially to San Antonio, all the members here. I really appreciate everyone who joined the call as well. As I said, this meeting is recorded already, so I will share the recording as well, and then all the information, his contact information, and also the list of documents, all the things. I will share it as an email to everyone. Okay. Thanks,
All
everyone.
right.
Have a good day.
Thank
Thank you.
you.